Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is regarding the allowability of various expenses like operating expenses, financial expenses and depreciation, especially in case where the assessee has started various ancillary activities which is related to the main business of the assessee, but the AO disallows these expenses only on the ground that the final product, commercial production has not started and there is no sale regarding that. So in the present case, the issue before the Honorable Supreme Court was that if the commercial production of the main product and the sale of the main product has not started, so whether this can be a conclusive proof that the business has not been set up by the assessee and the expenses can be disallowed to the assessee. This issue has been taken up by the Honorable Court in the case of Deputy Commissioner of Income Tax versus Daimler India Commercial Vehicles Private Limited, and this case is reported in 479 ITR at page number 221. The date of the judgment is 13th August 2025. The facts of the case are very interesting. The assessee was losing the case up to the tribunal level, but at the level of High Court, the assessee got the relief. In the present case, the assessee was incorporated with an objective of producing the vehicles and then making sale of those vehicles. During the previous year relevant to the assessment year 10-11, there was no commercial production of vehicles and consequently there was no sale. The assessing officer noticed that the assessee has claimed various expenses like operating expenses, financial expenses and depreciation, and the assessing officer showcaused the assessee that why these expenses should not be allowed in a case where the commercial production of the vehicles and the sale has not started, and why it should not be taken as if the assessee has not set up his business. The assessee explained to the assessing officer that in the present case the assessee has completed and started various type of ancillary activities which are related to the final product. So practically the business has been set up and these expenses should be allowed to the assessee. But the AO was not convinced and he disallowed all these expenses. Even at the tribunal level, the tribunal was not convinced with the assessee and upheld the order of the assessing officer. So when the matter was before the High Court was first time convinced with the submissions of the assessee that simply because the assessee has not commenced the commercial production of the vehicles and sale thereof for which the assessee has been incorporated, it cannot be said that only on that ground that the assessee has not set up its business. The court was of the considered view that since the assessee has commenced several activities for which it was incorporated, that is sufficient to qualify the assessee to claim the various expenses claimed by the assessee like operating expenses, financial expenses and depreciation. So the High Court allowed the expenses on the ground that the business has been set up by the assessee. The revenue filed the appeal before the Supreme Court and the Supreme Court also upheld the order of the High Court by allowing the expenses of the assessee. Friends, sometimes it may happen that when the assessee loses its case even at the tribunal level, so there should be some feeling that ultimately we are going to lose the case. But if we are very strong on our point legally or lawfully or on the substantial question of law, then we can make our case very smartly and we can get our case get through to the High Court also. So in the present case, the assessee convinced the court and the High Court was with the assessee that since the ancillary activity of the assessee has started and commenced, so it can be safely presumed that the main business of the assessee has been set up and commenced, so the expenses should be allowed to the assessee, which has been upheld by the Honorable Supreme Court. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Daimler India Commercial Vehicles Private Limited, and this case is reported in 479 ITR at page number 221, and the date of the judgment is 13th August 2025. Thank you, friends.